On Mirchi, New Jersey, it's Vijaya warmly welcoming you to the Immigration Hour brought to you by Nachman Phulwani Zimovcak, NPZ Law Group, accomplished immigration lawyers helping make the dream of US and Canadian immigration a reality. Managing attorney at NPZ Law, Ludka Zimovcak is here. Welcome, Ludka.
Thank you very much. It's good to be here, Vijaya.
Very good to have you as always, Ludka. And we have a question a listener asks, and he says, I filed my I-485 years ago based on EB2 petition, and I have been using EAD and travel documents since my H1B visa already expired. So how safe is it to travel with advance parole these days?
That's a very timely question. We get this all the time.
Mm-hmm.
And, it's for years we've been advising our clients, especially Indian clients, to maintain non-immigrant status. So in this case, it would be the H1B, because it's just not safe to be on a pending green card just in case something happens. It's always better to fall back on some type of non-immigrant status, either with H, whether it's L. So now even more, I have to say, while we always advise that now, we are emphasizing how important it is to maintain the status.
Yeah.
Having advance parole and even traveling is always a risk. And if you pull up a travel document, I'm sure this individual has it, it states it's not a guarantee that you will be able to enter the United States. It is discretionary, and any travel out of the US is always a risk when you're coming back. So, hopefully there are no underlying issues, and this individual will have no problem coming back.
Yeah.
But the recommendation would be to try to go back to the H1B status. So why that? Parole is not the actual immigration status, and maybe not many people know you're authorized to remain essentially in the United States based on the pending green card, but you, technically speaking, do not have lawful immigration status. And while for years this never been an issue, it looks like lately it is an issue. And we've seen reports where people might have been placed in removal proceedings, because they don't have non-immigrant status. I'm sure it can be challenged, but, it's right now it's an issue. And, this is for people that don't have status. But we have a lot of people that enter with visitor status, for example, and then file for a green card, which, it's been happening for years, but they are scrutinizing it right now. Preconceived intent. They're looking at it. Did you plan to file for green card? Did you sign lease? Did you put your kids in public schools before you even entered? So, bottom line is it's really important to maintain or get non-immigrant status. So in this case, it would be great to just get back into H1B status. It's always a possibility. Get new H1B, go to the embassy, get the visa, because it's definitely safer. Staying here on pending green card and kind of, being in limbo. So I hope it answers the question. It's definitely complicated. It's not that simple as always. Immigration, it's gray area of law.
Very gray.
But it's never a guarantee that the person will be able to come back.
Well, thank you so much, Ludka, for that timely, information. And I think it'll help a lot of people right now in this scenario, in this situation. And appreciate your insight on this. And of course, that's Ludka Zimovcak with the NPZ Law Group, your one-stop shop for the entire range of US and Canadian immigration matters. Don't hesitate to reach out to them today. Visit visaserve.com or call them at 201-670-0006, and remember to mention Mirchi to get a special discount off your consult. Much more with the NPZ Law Group, your friend and guide for all things immigration. We'll be back in just a moment. Keep listening to Mirchi. It's hot.